Welcome. Welcome to Maryland Comp 101, brought to you by Chartwell University and Upstairs Barber College. We are going to be covering the basics today. Things like what claims are compensable, what happens when you get to a hearing, the always famous question, how do you deny a claim in Maryland? And I think I'll turn it over to Jack for some overview. If you have questions, we would like to take them as they come in if we can. Please use the Q&A feature at the bottom of the screen. We will try to get to questions as they come in. If we get overwhelmed, we'll try to get everything sort of at the end, but we will try to answer them. So over to you, Jack.
And if we get overwhelmed at the end, then we'll email y'all with the answer to your question after this webinar, since it's only an hour. But welcome to Maryland Workers' Compensation 101. And Maryland is a permanency state. That's the main difference between Pennsylvania and Maryland or some other states. And so instead of getting wage loss benefits until you're able to go back to work or you're recovered, Maryland, you can cut someone off once you have a medical opinion that they're at maximum medical improvement or full duty or things like that. Unlike other states, including Pennsylvania, that have a reasoned decision standard, so you'll get a decision that you can understand how the workers' compensation judge reached the conclusion, Maryland has decisions as short as one sentence. There is no reasoned decision requirement at the first trial level at the Maryland Workers' Compensation Commission. And so that's what you'll usually do. And the Maryland Workers' Compensation hearing process, right now, it's in person. They're limited hearings with all the COVID restrictions, but Maryland also has the ability to do video hearings at the request of the parties. So right now the commission says that the preference is in-person hearings, but if someone requests a video hearing, they'll grant that opportunity. And if someone objects to a video hearing or an in-person hearing, the commission wants a good reason for it. So maybe the claimant lives in North Carolina, but if the claimant lives in Frederick and the hearing's down in Beltsville, that's not a good reason to have a video hearing in the commission's view. We'll see how long this process goes. Steve and I were just talking as well that there's not a lot of case law in Maryland, because once you get this one sentence decision out of the commission, the parties can appeal it, but the appeal goes to the Civil Circuit Court in Maryland, and that's usually a full jury hearing. So we were mentioning the, whether a needle stick happens to be compensable or not, you're not going to find case law on that in Maryland, because any appeal that's going to have a written decision goes to the circuit court, and that appeal process probably is costing at least $8,000 and up to take a case on appeal. So that's why, I don't know if Steve, can you hold up a treatise of Maryland versus Pennsylvania?
I can. I'll try to get both. Here is the Maryland treatise, and I might need two hands. Here's the Pennsylvania treatise. It's much thicker. And getting back to something you had mentioned, while we're having in-person hearings now in Maryland, when we first hit lockdown, they shut everything down. And so now what they used to do is we'd have cattle call hearings down in Maryland. So you would have a list of 25, 30 hearings, all scheduled for 9 o'clock in the morning. Everyone would be milling about. And these hearings are not long hearings. They're turned over quickly, but they shut everything down, which caused a backlog. And now they're slotting hearings so that we can do social distancing. That has caused even more of a backlog. So right now, I think in January, I'm getting hearings in April. That's how long the delay is to get a hearing. I'd say before COVID, you're probably looking at 60 days after you filed issues. You'd probably be on a list for hearing. That sound about right, Jack?
I'd say yes.
Yeah.
That's the other thing about Maryland is, well, I'll start with the hearing process. The one sentence decision, the commissioners have wide latitude. And recently I had a hearing where the the claimant was trying to get ongoing wage loss benefits, and the commissioner said, I'm not going to award you ongoing wage loss benefits, but I want to award you something. Then she looked at me saying, what would make sense to award a closed period of compensation to this person? So it was almost like dialing for dollars, but it's also sort of like the Wild West going in there, because it's reduced evidentiary standards. And so I'd say they used to say this about Pennsylvania workers' comp. It's sort of like what civil trials were 100 years ago in terms of no discovery process to speak of.
Yeah.
The other,
Oh, I'm sorry. Go ahead, Jack. I'm sorry.
I'll just finish off with the other advantage of Maryland is, since it takes so long to schedule a hearing, you you don't have to worry about not being able to get an IME if you need an IME or anything like that. You have plenty of time to schedule stuff like that.
Yeah, I completely agree. And I was going to say, Jack and I both cut our teeth on Pennsylvania law. You know, I've been practicing Pennsylvania law for 24 years. I'm also licensed in Maryland and the District of Columbia. So we both, when we tend to compare things, is to the Pennsylvania system, because that's what we more or less grew up with. And that is also, I think, one of the main differences. We're talking about the commission. They're not technically judges in Maryland. There are 10 commissioners. They are attorneys. They're appointed by the governor. And the lack of discovery is sometimes, it's insane. You know, in Pennsylvania, we will send out requests for discovery, get everything the other side has. Technically, in Maryland, they have to turn over everything 3 or 4 days before the hearing. You know, here's what we're going to rely on. Well, thank you. It's very, very, very different in that respect. So, Jack, do we want to talk a little bit about what is compensable in Pennsylvania? I mean, in Maryland. So,
Oh, wrong seminar
yeah,
or
sorry.
webinar.
I'll do that all day. I can assure you, I'll do it all day.
I guess a difference between Maryland and Pennsylvania is the Maryland law does distinguish more between an injury arising out of and in the course of employment. It has definitions for that. The accidental injury, it's like some condition that happens on the job, basically, in simplified form, and something that is a, a consequence of the job, as opposed to like an idiopathic problem like having a stroke or passing out or something that has nothing to do with employment but happens to be occur during employment.
So, if I'm working and even say I'm working at a desk and I have a stroke and die, is that going to be compensable in Maryland?
Um, no, unless you can tie it into some aspect of the employment. I think Maryland is a little more restrictive than Pennsylvania, and I cut my teeth on California law. But in Maryland, if someone passes out unrelated to work and you fall on the floor, that's a non-compensable injury. Whereas in Pennsylvania, if they bump their head on the floor, that's a compensable injury. Maryland requires a little bit more, like you're up on a ladder and fall off the ladder because of an idiopathic problem, then the consequences of that fall would be compensable, but not simply falling on the floor.
And in the course of, it needs to be in the course of, also referring to the time and the place of the accident and the circumstances upon which it occurs. So, you know, did that injury occur within the period of employment at the place where the employee may have been engaged in his duties? So another difference between PA and Maryland, if I get assaulted by a coworker because the coworker doesn't like my face, in Maryland, that's going to be compensable. I've had several claims where we've had stabbings on the job where it was compensable. In Pennsylvania, we had the personal animus defense, where you could say, well, it was something personal. It had nothing to do with the job, therefore it would not be compensable. Which sort of brings up another, you get stabbed in Maryland, say I get stabbed in the abdomen. If I have scarring, that's actually going to be compensable in Maryland, unlike Pennsylvania, where it's pretty much from the neck up. So it's something else to take into consideration. I actually had a case where it was a horrible stabbing. They were seeking scarring benefits. They sent, again, no discovery, no pictures of the scarring before the hearing. 2 days before the hearing, I get pictures I lied. 20 minutes before the hearing, the pictures came across, and then I went in and asked the claimant to lift up a shirt before he went into the hearing, and it was absolutely horrible. I called my adjuster on the spot and sent the pictures. Said this is something I don't think we want to go to a decision. We end up resolving it before even going to the hearing. But that's something to keep in mind regarding things like assaults, scarring. It's much more compensable in Maryland.
And
How
just
about things like softball, Jack? My Chartwell in Maryland, we have a softball team. I'm rounding. They pay for the uniforms. They pay for dinner afterwards, and I pull a hammy rounding first base. Is that going to be compensable?
if it's depends on how the employer is compelling the employees or not, and as well as what benefit the employer gets out of that activity. We did have a question. I was going to mention on the course of employment, a case where the injured worker was on the employment site but was interested in some construction they were doing and walked over to the other site that he wasn't supposed to be and had an injury. That was not in the course of employment. That's an example of not being in the course of employment. We did have a question come in about slip and fall in the parking lot on the way to work. How about that, Steve?
Well, I would think that if the parking lot is being maintained by the employer, they're not technically in the course and scope while they're walking in. In Pennsylvania, that would most likely be compensable. But in Maryland, if they're not, I think if they're not on the clock at that point, it might not be compensable. What do you think, Jack?
Well, I think whether it's on the site of the employer's facility or not is the factor in Maryland. I'm just looking at questions coming in. There's another question: if a claimant is released to light duty and is under an award of TTD, can the insured cut off TTD benefits? And does the employer need to offer work to cut off TTD? And that would be a question of whether the claimant is at maximum medical improvement. If not, then the employer would want to offer light duty work before cutting them off of
Yeah,
TTD.
yeah, correct. I mean, if assuming an individual, if we talk about basics, assuming the individual is off of work totally and is receiving the temporary total disability benefits, once you have an MMI opinion, then that is either from an IME doctor or it is from the treating doctor, you can automatically cut them off at that point. There is a form C6, thank you, C6, that you simply file, say when the last check was mailed out, the period it covered, and why you're cutting them off. And I would also attach the medical report indicating that they've reached MMI. That's an automatic. If they're simply released to light duty is not enough. If you have work within those restrictions, I would offer it to them. How about defenses, Jack? Let's say if we have an employer that requires a drug test after every injury. I have several clients that do that. Let's say I get my arm cut off by a machine and I test positive for methamphetamine. What's the defense? Can we simply outright deny that claim for intoxication?
Sorry, Steve, I was reading one of the questions.
Okay, why don't we get to the question first and then we'll come back.
Let's see, can the employer force workers into a return to work program in Maryland where they would do nonprofit work and be paid by the employer if no light duty is available? I'd say, I mean, if that's funded employment, that's a possibility. But again, in Maryland, you have the aspect of being able to cut folks off if they're at maximum medical improvement. And that's usually what happens, as opposed to like trying to provide funded work for the employee.
Yeah, I mean, I believe funded work would be allowed if that person's not. If we have an individual who's not at MMI, doctor's still saying you need treatment, but they're releasing you to light duty. The employer has no light duty. I think you could still offer work if you have funded employment out there. If there's some work you could have them do, I think you could offer it to them. Yes.
And Steve, you were talking about, I have a case where it was some sort of facility where they used box cutter to open boxes and things like that, and they were sort of horsing around, um, pretending they were doing martial arts, and one employee got cut, and so that would be denied as horseplay, not engaging in any kind of activity that is the benefit to the employer. I guess there's one aspect. I had another case where some of the horseplay was known about by the employer, and that was found to be compensable because it was condoned by the employer. Um,
And going and coming rule in Maryland also applies. Normally, if you have a set place of work and you're going to and from work, you're just simply commuting to and from work, and you are in a car accident, that's not going to be compensable. Of course, it's if the employer is providing the transportation, then that's a different story. It could be compensable.
so I'm just like, we'll see how long we go with questions, because I'm looking at questions and not looking at participating in the webinar. But
Go
I
ahead.
guess here's another question. If you offer work within the restrictions the claimant has and claimant refuses, can you suspend benefits? And the answer is yes.
Yeah. And we were talking about how Maryland's much like the Wild West. I try to tell my clients, be aggressive, right, Jack? I mean, I think rather than saying can we or can't we, I would say do it. Do it, and we can decide later. There are not nearly as many penalties, things like attorney's fees that you're going to have to pay. I would say be aggressive. If you think you're in a situation where you think you can lawfully suspend or cut off benefits, I would do it. I think you have a better chance in Maryland of having it upheld and having a legitimate reason for cutting them off.
And you just have, for medical benefits, we mentioned for indemnity benefits, you use a C6 to terminate compensation. For medical, it's a C10. It's a form for that as well. Here's another question: is if there's a fall in the parking lot, wouldn't an employer prefer to have it be compensable to avoid tort liability? What do you think about
Possibly.
that, Steve?
Yeah, possibly. I mean, I would say that sort of goes to the Maryland, the way the law is set up. If it's a slip and fall, as soon as they hit MMI, you can cut them off, and they're not going to be able to sue you in tort, assuming it's your premises and you were responsible for cleaning off the parking lot. Yeah, I'd agree. Would you agree with that, Jack?
Yeah, as long as it's your parking lot. I mean, it
Yeah.
might be an off-site facility as well.
Yeah, I mean, if it's an off-site facility and you're not maintaining it, and it turns out it's not in the course and scope, you still do get subrogation under Maryland law as well. So if they try to get comp because you're renting that parking lot and it's all employees are forced to park there, but you're not maintaining it, and they do maintain a third-party action, you will get subrogation.
And not to get off topic, but there's, unlike some other states, there's assumption of the risk in Maryland. So, I mean, if there's an ice patch and you see it, I mean, tort exposure might be less than it would be in other places, because Maryland still has that concept of assumption of the risk. You saw a patch of ice and you went over it anyway or something.
And while we're talking about things completely unrelated, and I don't know the answer to this, so I'm asking it. How about comparative negligence? Is it a 51% in Maryland? I'll be honest, I do nothing but workers' comp, so I don't do third-party work.
Yeah, they don't have comparative fault in Maryland. So, in fact, on the firm's website, I think we just had a blog on that in Maryland in terms of slip and falls on sidewalks. So, not to get off the compensation aspect, Steve, you want to go into occupational diseases in Maryland?
Sure. Occupational diseases are in fact compensable in Maryland. By definition, in Maryland, an occupational disease is any ailment, disorder, or illness combined with a disablement caused by the conditions of employment and which manifests itself over a period of time. So the disablement portion of that, the event of becoming partially or totally incapacitated performing work as a result of this disease, and there must be lost time from work constituting the disablement, and the benefits become payable as of the date of the disablement. So you do have to be out of work. And I believe there's the notice issue also, Jack, for a occupational disease claim is the date that it first becomes disabling. Is that not correct?
I believe so. And the other aspect of that is the last injurious exposure is the date of injury in Maryland. So you might be getting into, if you're talking about, how about asbestosis or something where you have latencies, then you would get into medical experts fighting over what's the latency period if you have someone who's been in um, the shipping industry for years and years.
Right. And as far as defenses, when it comes to occupational diseases, the OD, the occupational disease, must be caused by the employment. But if the claimant can show that at least part of the disease is due to the occupational hazards, even if the majority is due to a pre-existing condition, it may be compensable. So again, I guess an individual working in the boiler industry who was working with asbestos their whole life, they're going to be able to show that at least part of that disease, if they have asbestosis, was caused by the employment. Um,
I
the,
guess on
I'm sorry.
carpal tunnel syndrome, it might be that the claimant tries to tag, an employer the person had maybe 6 months ago, but continues to do the repetitive type activity that may continue the injurious exposure. You get into things like that. And the last employer, or the last employer who employed the claimant at the time of last injurious exposure is the employer that's going to get tagged with I'm sorry, the occupational disease. All right, so
So if we have a long list of, I remember, I did a very few, but I did some black lung hearings in Pennsylvania, and there you would have sometimes 10 employers lined up deciding who was the last, who's had the last exposure. So it's much like that. If I'm that last employer on the hook and they were working with friable asbestos, I'm going to be the one that's paying the benefits, correct?
that's right, and I think it's evident that I'm looking at an outline that we'll make available after today's seminar, but moving on to the next section was hernias. There's a presumption of compensability for hernias unless it's a pre-existing hernia. And we've had those cases where the guy or person has a pre-existing hernia that becomes symptomatic, but in Maryland, it not only has to be symptomatic, it has to be so aggravated to cause an immediate need for surgery. So we've had those cases where there's symptoms but no immediate need for surgery, and defending them along those lines. How about jurisdiction, Steve?
I'll touch on this because I have a case that's near and dear to my heart dealing with jurisdiction. If you are injured in the state of Maryland, you are going to be covered by the state of Maryland, except if the employer, employee, and a contract of hire are in another state, and the employee is injured in Maryland while working temporarily or intermittently in Maryland, there will be no coverage. If the non-resident employer has coverage in another state, which covers the worker in Maryland, and the other state has similar laws exempting a Maryland employer and employee from the same circumstances. I have a case that was picked up under Maryland law that probably shouldn't have been. He was a Pennsylvania resident. He was working for a Maryland corporation, but at a drilling site in Pennsylvania, was injured by this big metal hose. It was a very serious injury to his foot that, of course, turned into complex regional pain syndrome. We were fighting over a spinal cord stimulator. The carrier paid benefits originally under Maryland law, and I understand there could be some reason to do that because in Pennsylvania you can be dealing with a much longer claim and a much more drawn out claim than you would be in Maryland. But really, Maryland didn't have jurisdiction in that case because the gentleman never worked a day in Maryland, was never going to work in Maryland, worked the entire time in Pennsylvania. And what happened was they started paying in Maryland. He found himself an attorney in Pennsylvania who immediately filed a claim petition and said, now we prefer not to have this in Maryland. We want it in PA. And the good news of all that is we ended up settling it under Pennsylvania law, and they agreed to settle the Maryland case as well. But if you have an individual, just because they're working for a Maryland corporation, unless that injury occurs in Maryland, they're probably not going to have jurisdiction. And however, if for some reason we settled the Pennsylvania case and the Maryland case stayed open, any benefits that were paid under Pennsylvania law, we would have received a credit for under Maryland law as well. So there's not going to be any double dipping.
And that's what I'll just say. There's lots of questions coming in, and we're trying to address them. And if we don't get to them during this webinar, we'll address them with an email to you. I think because I was trying to keep up with all the questions, the one aspect, like Maryland, there's some restriction for coverage of a non-resident in Maryland, but it says if the other state has the same provisions exempting in a Maryland employer and employee under the same circumstances. We don't have that with Pennsylvania, because Pennsylvania, if there's an injury in Pennsylvania, that's a compensable injury in Pennsylvania. So Maryland restriction doesn't apply to Pennsylvania residents, and the other because Pennsylvania doesn't have that restriction for Maryland residents. The other thing is in Virginia, if you have a Virginia policy with an injured worker in Maryland, if that injured worker is undocumented, that injured worker isn't covered under that Virginia policy, and then you're going to get into that's a Maryland workers' compensation case. If that injured worker wasn't excluded from the policy in Virginia, then that could be covered under that Virginia policy.
Well, I was going to say, one of the questions actually asked us to go back and discuss that methamphetamine that I had brought up. So intoxication as a defense, Jack. I test positive in a post-accident drug screening for whatever it is. Let's use methamphetamine. It's a fairly hard drug, and I injure myself because I put my arm into a machine while I'm high. Is that a defense in Maryland?
I think it's more of a defense than it is in Pennsylvania. In Pennsylvania, it has to be the exclusive cause of the work injury. In Maryland, it just has to be a primary cause. And a couple of years ago, I had a case where it was a death claim, and they never even pursued the death claim because the guy, I forget what his blood alcohol level was, but he was speeding on back roads in a work truck and ended up dying in an accident. So that was something I anticipated they were going to be pursuing workers' compensation, but they never did.
Right.
Whereas in Pennsylvania, they would.
Absolutely. Yeah, absolutely. Because in Pennsylvania, you've got it's almost a but-for test. Unless you can prove that intoxication was the but-for cause of the accident, you're not going to prevail. And then you get into trying to find a toxicology expert in Pennsylvania that can say, yes, the blood alcohol level at this level, it had to be the cause of the accident. It's very, very difficult to prove. I think you're correct. In Maryland, if you can prove that they were high at the time of the accident, I would say deny it and fight it. You have a better chance of winning. Just trying to see what.
So instead of looking at the questions, which we'll answer if we don't get to them, just continue on. Let's see.
I was gonna say, can we start? Maybe we should talk a little bit about basics. I'm working at my job. I pick up a box, feel a pop in my low back. What do I have to do? What are my duties at that point, Jack?
Well, you have to notify your employer, and there is a notice requirement in Maryland, but it's never, you have to show prejudice if there is no timely notice, and that never happens. And the commission, that's the other thing, the commissioners get together and sort of come up with sort of procedures, how informally they'll address things. And so the notice requirement is on the books in Maryland, but it never is an obstacle to getting workers' compensation benefits because of that prejudice requirement. Once the employer has notice, the employer is to file a first report of injury. And if the employer doesn't file a first report of injury, you don't have a statute of limitations limitation for the claimant to go ahead and pursue benefits.
Right. So that I was going to say that's why I would press. I would be tell my clients, once you get notice of that injury, make sure you file the first report of injury. That's Form 1A. And if it's a death, you need to file that within 10 days of the death. If it's an injury, you're supposed to file it within 10 days of 10 days of the claimant being disabled for 3 days or more. But I think it's safe. I would rather be safe than sorry and just file it when you know that there's an injury, because that starts the tolling of the statute of limitations.
And someone, I think one of the questions that I was perusing through had a question about paying medical without prejudice to being later able to deny a claim, and that's the case. You can pay medical without admitting a work-related injury, but you can't pay compensation benefits before that um, employee claim form has been filed with the commission. And in fact, there's a penalty provision for paying wage loss or compensation benefits without that form being filed with the commission. So lots of people instruct the injured worker that I can't pay you anything until you file the form. Some people mail it to the injured worker, but more likely he can go on or she can go online and file it him or herself on the commission's website.
Yeah, correct. And I've, it's one of those strange things where you have I'm giving advice to a client who says, well, this person was injured. We're not disputing that they were injured. They're out of work. I want to pay, but I haven't received that form. And I tell them, you can't pay. And I have done, I have actually sent letters to claimants enclosing the form and telling them, here's the website. We want to pay you, but we can't do that until you complete this form. So let's assume that I do file the employee claim and I say I hurt my back. These were my wages. At that point in time, what happens? Once the employee files that claim, what does the commission do?
Well, it's a little different in Maryland than Pennsylvania because the employer is, if the employer disputes a compensable injury, then the employer has to file a C40D once it gets notice that the employee claim has been filed with the commission, and you have a limited period of time to do that. And so it's the employer is the moving party by filing issues saying there was no work-related condition or the disability is unrelated to a work-related condition. And that sets the ball rolling in terms of going to the commission. If the employer admits a workers' comp injury and either is paying compensation or not, the employer can send in the C40D, not dispute the injury, and then the commission will issue what sometimes is called an automatic award, and it purports to find stuff other than just that there was a compensable injury, but you can dispute causal relationship, average weekly wage, and stuff like that later in the claim. But that automatic award just means there's a compensable injury. So if the employer wanted to dispute injury and didn't before that automatic award issues, then in the time of COVID, you can do a request for rehearing with the commission, and the commission has relaxed its rules because knowing delays in the mail and things like that occur. It's either a request for rehearing or you file an appeal to that if you're still disputing that there was a work-related injury.
Yeah, and I have found on some of my cases how I've been impled on some files, and suddenly, I enter my appearance on their automated system, so I should be getting hearing notices and all that good stuff. And suddenly I get a decision from the commission tagging my client as being the compensable employer when I can assure you they are not. I immediately file a request for a rehearing, indicating that at that point, when I tried to get back into the file, I was being told I hadn't even entered my appearance, which was not correct. So I sent an explanation in with why we needed a rehearing, and they just gave me a rehearing. And in that case, I actually reached out immediately to claimants counsel and to the other defense counsel and said, I instructed my client not to pay. This is ridiculous. And claimants counsel agreed. He said, we're not shooting at you anyway. Don't worry about it. Don't pay. Which in Pennsylvania would not happen. I can assure you that once we were told to pay in Pennsylvania, that claimants counsel wasn't going to say, no, don't worry about it. We're aiming at somebody else.
Another early document, that's in other states, the statement of wages. In Maryland, it's typically the 14-week period prior to the week of the work injury is what you use to calculate a wage statement, but the commission has latitude. If there's vacation time in there or off work for some other reason, the commission has wide latitude to calculate the average weekly wage differently. One of the things I see quite often is that the average or the wage statement completed by the insured isn't correct. I'd say most of the time the insured will put wages for the week of injury, um, and they shouldn't be used. And so if you're underpaying compensation because it's off a week or two, um, you're going to owe that. And it's not no limited period of time where you can say, sorry, you're too late for disputing how we paid you. They can come back at any time if the wage statement was incorrectly calculated. So um, when I see that, I either ask the carrier or the employer for 1 or 2 extra weeks of wages so we can correctly file the wage statement with the commission. And the other thing is the commission likes to have that information in the file before you go to hearing, because they can look, they review the file. In fact, now we're electronically submitting our exhibits at least 3 days in advance of a hearing. So the commissioners look at that stuff and they know what the average weekly wage is, and they have your exhibits before the hearing. So I think it would make sense to tell employers, you know, early on that we need additional information so you're not doing it over again a year or two later when you go to hearing.
Well, let me ask you this, Jack. Let's say we have a case where we're not going to dispute liability. When as an employer or a carrier, am I to file that wage statement? Because we'll have what I do see sometimes is there's the employee claim and they will grossly inflate their wages compared to what they actually are. And then I'll get an order from the commission ordering me to pay at a much higher rate because it's based upon that employee claim. Should I file that statement of wages with the form indicating I'm not going to contest, but that this is what the average weekly wage is?
Well, if the commission sends out that automatic award and it has the incorrect wage, you have the opportunity to dispute that up until the date of hearing. So it's not like you have a time period where you have to file it, um, at some point before the hearing date, but it's just sort of good housekeeping to be able to correctly have it calculated on hand so you can file it at any time before you go to hearing at the commission, because at the first hearing at the commission, that's one of the findings they're going to make. What is the average weekly wage? And that's under the statute. They're supposed to make that finding, so they don't like it if someone's disputing it at that point.
No, understood. And if I'm going to pick up the claim, am I okay paying based upon the average, what I believe the average weekly wage is, even if they
Yes.
order me to pay at a higher rate?
Yes.
Okay.
That's why I said those automatic awards, they say maybe lots of stuff. They may say they're totally disabled for the period of X forward and all this, but it's all subject to disputing everything other than you have an accidental injury.
Right. Understood. But I just want that for an adjuster who has a file, who decides, well, I've discussed this with the employer, we're not going to fight it, I want to pay. I would pay based upon your average weekly wage calculation, because you don't want to have a giant overpayment.
Oh, no. Yes.
Okay, that's all. I just wanted to make that clear. Maybe we should talk a little bit about temporary total. What is the rate that I'm going to get paid at? So I get hurt. I have a doctor that takes me out of work for this low back injury, and I think I'm starting to get pain go down my leg, Jack. I don't know, but this is getting worse every day.
Actually, I'll show. Here's the spreadsheet for compensation benefits. The commission establishes the compensation rate as of January 1 every year. And for 2021, the temporary total disability indemnity maximum rate is $1,050. And I guess it's sort of sad because it's been going down for the last 3 years after going up, for years and years. So the subject to that maximum, the temporary total disability indemnity rate is 2/3 of the average weekly wage.
Is there a minimum?
I believe there's a $50 minimum.
Correct. That's
You don't get into that much, but
No,
I guess the other aspect difference from other states is if the injured worker isn't at maximum medical improvement, is working light duty and receiving a partial. That partial is 50% difference between the pre-injury wage and the post-injury wage. And other states are a little different. I think Pennsylvania is 2/3 the difference. So in Maryland, it's just half.
correct.
Let's see.
And how many days of work do I need to miss before I get paid?
Let's see, I believe it's 3, Steve, but if it's different, let me know.
No, I don't mean to be quizzing you. This isn't supposed to be a pop quiz. I apologize. Three. It's three. Yeah, I'm not. That's not, I wouldn't want you to do that to me. I
I
apologize.
guess, I mean, stuff like, I guess we get stuff that's sort of like down the road a little bit. So we don't deal
Correct.
with a lot of the initial things on starting up claims, but in that's a big difference because most of the people in claims, that's what they do.
Correct.
Um,
And
look
if I'm
at,
correct, and if I'm not paid, I was just looking at our outline. If I'm not paid on the date of injury, then the date of injury will count as one of those 3 waiting days.
and the other thing, I guess I mentioned that the commission establishes the average weekly wage for the calendar year each year. And there is no going back and giving COLAs or anything like that. That if you have an injury in 2018, you're going to have the 2018 compensation rate for temporary total disability, partial disability, I guess, and then we can get into the permanent partial disability because that's
Yeah, I was just because that's actually where the meat of most of these claims uh, arise, and we're already probably 40, almost 45 minutes into this. So yes, let's talk about permanency. Since Maryland is a permanency state, you ask, well, what exactly is permanent partial disability? First, the employee has to be at MMI for the commission to be able to find a permanent partial disability. Uh, the they have to be at MMI. Both sides at that point would obtain what amounts to an IME. You know, if we're getting to the point where we have an MMI, I would tell you obtain your IME. You know, if I'm dealing with a back, find an orthopedic surgeon who deals with backs. They're going to examine the claimant, and they're going to use the AMA guides, the 4th edition, and decide exactly what the percentage of the impairment, the permanent impairment is. And you're going to see cases where you'll get your IME that says 0% and the other side says 25%. And the commission does not have to split the baby. Some of that is going to depend on the commissioner you get. Correct, Jack?
that's correct. And the other thing is that Maryland has the 5 factors in addition to the AMA guides 4th edition. So the guides are almost a more an objective assessment, but the 5 factors can be all over the place, and you'll find the claimant's medical might have for a finger, it's like 2%, and then the 5 factors, you get to 50% or something for a finger.
Correct. And I would say if you're doing your own IME letters, make sure that you indicate, even though most of the doctors are savvy, if they know Maryland law, they're going to know to include the 5 factors. But I would always say using the AMA guides and the 5 factors, you know, what's your percentage? And then once we have a percentage to decide, well, what exactly is the claim worth? Maryland has scheduled members. You can go into the law, and every body part is worth something different. So I'm not going to run down this entire list, but my thumb is worth 100 weeks of compensation. My hand is worth 250 weeks. A foot 250, a leg 300. There's also hearing loss you can obtain, and then if you don't fall under the thumb, the fingers, the great toe, the arm, the hand, there's something called other members, and that's what a low back is going to fall under, is this other members. And under the non-scheduled members, it's a maximum of 500 weeks of disability. And I'm sorry if my phone is going off and you're hearing that. I apologize. No one ever calls me except for when I'm doing a webinar, I can assure you.
Go ahead and answer it, Steve.
No, I am not going. You know what? I can assure you right now, if I answer it, they're going to ask me about my car warranty and why I'm not extending it. That's the only calls I get.
So just, I don't know if anyone's asked, but the AMA guides is the objective aspect of rating an impairment, and the 5 factors are really subjective. It's pain, weakness, atrophy, loss of function, loss of endurance. And so that's other cases. That's I guess taken as the body of as a whole. So the back, a hernia, a neck injury, those are non-scheduled injuries. So you're going to get a percentage out of 500 weeks. 500 weeks is loss of use of the body as a whole. And most of your claims are back claims. And so you're going to get some aspect of percentage of loss of use of this 500-week period to calculate your permanency for the back claim. And the other aspect of that is, and I did a blog a couple of months ago, we have a tier system in Maryland for rating permanency. And so for a back, let's say you have a 10% impairment, that's 10% of 500, that's 50 weeks. 0 to 75 or 74 weeks is called tier 1, and you get a lower compensation rate for those injuries. If you go to 75 to 250 weeks, you go to tier 2. That's a higher rate of compensation. And we'll be sure, I mean, I have all the comp rates for all of this stuff on this chart, so we can send that out after the webinar. But more than 250 weeks is called serious disability. And that is sort of expensive. And I had an example using a 2018 injury claim as an example. A 74-week award for a 2018 injury claim is worth about $13,500. If you just go to 75 weeks, you pop into the tier 2 level with a higher compensation rate, and it doubles. It's 27,500 approximately. And then the more striking difference is between tier 2, 249 weeks of compensation. If you 249 weeks of compensation for a back is worth in 2018 like $91,000. You add 1% or 1 week, go to 250 weeks, that pops you into tier 3 serious disability. So you get a higher rate, but not only a higher rate, you get 1/3 additional weeks. So while a 249 week award is worth $91,000 approximately, just 1 more week, 250 week award is worth $274,000. So that's quite a difference. And that's, I don't want to be popping around, but that's normally what we're dealing with in comp. It's like whack-a-mole. These injured workers that have awards, they have 5 years from the last payment of compensation to get additional benefits for worsening. And so it's like a little timeline. Everyone, claimants, attorneys have this 500 or 5-year statute. And so when this 5 years is coming in, they go take them back to one of their doctors, and the doctor has an opinion of worsening. And you just go tick, tick, tick up the scale, trying to get to the next tier level to get more money.
Yeah, and that's where and I find a lot of the negotiating and arguing comes down to, you have an individual who hasn't had any type of, I have a back claim but no surgery. I haven't had any surgery. I've had some physical therapy, no injections, and they have a rating that puts them into a second tier, and we have a rating that puts them in first tier. And many times I'll have clients say, we don't think this is a second tier case. There's been no surgery, and I don't disagree. But it's a situation where I would also tell my client, if you can get a total settlement on this case, it's so much better than having those 5 years ticking and just waiting for them to come back and get more money. I would always say try to resolve it for a full and final. And a lot of claimants councils are open to that. They'll take a few $1,000s more, $5,000 more to simply get the case resolved completely.
I'll say it's not, I don't think they're as willing as they are in Pennsylvania.
Yeah.
I mean, a compromise and release agreement in Pennsylvania seems to be the name of the game, but in Maryland, it's called let's see, agreement of final compromise and settlement. It's the same thing. But I mean, on some of these cases where, someone's on Social Security disability with a back problem, and all they're doing is running out the clock every 5 years, gone for the brass ring. Some claimants attorneys aren't real interested in doing a full settlement.
Right.
I guess another aspect of full settlements in Maryland is, even if someone isn't Medicare eligible, unless you have an opinion that they don't require any further medical treatment or they're all better, the commission wants you to do a medical cost projection and attach it to your settlement. So you could have someone who isn't on Medicare, isn't anticipated to be on Medicare anytime soon, and yet you have to do a medical cost projection and then have like whatever that comes to as part of the settlement to be assigned for future medical care benefits. I
Yeah.
guess the one aspect in Maryland, though, is in fact I have a fairly serious claim, um, but some of the claimants, IME doctors, they could say this guy is really bad off. And then you say, well, we settled the claim. Will you give us an opinion on whether he requires further medical treatment? And they'll comply and say he doesn't require further medical treatment. So bam, you don't need to have a set aside.
I just settled a case like that. And it wasn't that it's a horrible injury, but they just asked their doctor for an opinion that no more medical treatment was going to be needed, and we got it. And something we should talk about, if you do settle cases in Maryland, there is no need for a hearing in Maryland, unlike Pennsylvania, where you have to go have the judge issue a ruling that the claimant understands the legal significance of what they're doing. No such requirement in Maryland. And I find that claimants counsel, for the most part, will draft most of the agreements, we'll review them, we'll sign them, they upload them to the commission, and you'll then get an order from the commission approving them. Or if the commission wants more information, they will in fact request a hearing.
I guess, let's see. The another aspect in Maryland, which is sort of nice as opposed to Pennsylvania. In Pennsylvania, the claimant's attorneys look to you to pay for their costs of litigation. In Maryland, that doesn't come up. There's no aspect of the employer or insurer having to reimburse costs of litigation. That's deducted from the lump sum settlement.
Yeah, correct. They will actually put on the settlement the cost of their IME, the cost of the attorney's fees. There's an affidavit the claimant has to sign, and pretty much outlines, I know what I'm paying, I know what I'm getting. And for them, I'd say for the most part, assuming claimant has an attorney, it's a fairly straightforward process. I don't want to say it's rubber stamp, but it's a fairly straightforward process. I was just thinking, Jack, we have about 7 minutes left. I was going to say, I think we should touch just briefly upon vocational rehabilitation, because I have a couple.
I agree. That's
I have
where
a couple cases in there right now. So you have a situation where I had an older claimant who was probably in her, I shouldn't say older, not older, in her 60s, in her low 60s, so not quite retirement age. She has a back injury. She eventually gets released to come back to work, but not to full duty. She has permanent restrictions. An FCE was completed. So let's just say, for argument's sake, we have permanent light duty restrictions, and the employer has no light duty work. She's entitled to vocational rehabilitation services. So what does that mean under Maryland law, Jack?
that means it's probably another 8 grand
That's
with
right.
60 days of job placement services that don't go anywhere.
And
Um,
what? Oh, I'm sorry.
one
Go ahead.
one interesting aspect, I don't recall which commissioner said it, but if someone's messing around in voc rehab, the commissioner takes note of that when you go to a permanency hearing. They have that stuff filed with the commission website. And so if they see that someone was messing around in voc rehab, then they're going to gong them when it comes to permanency awards.
Yeah,
Um,
I was gonna say that, and that's, I've got that example that I was giving you. This woman, her counsel was all about, let's get the voc started, because when voc starts, we need to start paying TTD again, if they're considered vocational benefits, but it's really paying TTD while we're going through voc. And if the claimant is not participating fully, you can then cut them off. And I had this individual who just refused to attend Zoom meetings, refused to do anything, quite frankly. And eventually we just cut it. We cut her off and said, well, we'll take this to a hearing.
and
I'm not.
that's what the commission has, an expedited hearing process for voc disputes. They have an assigned commissioner, so someone will file a voc dispute. You have to put your cell numbers on it, and she'll within days have a telephone conference to see if it can be resolved without a hearing, or whether she scheduled or he scheduled it for hearing. I did want to just make sure we get in another aspect of appeals. I mentioned they're expensive, and no one, rarely do these appeals go down. It's probably less than 5% of the cases. Um, an aspect that would I guess is one of the benefits of appealing a case is you can settle it on appeal and then, in a contested or disputed fashion after the commission has already issued an award of benefits and get out of some liability. Like the other aspect, you don't need a medical cost projection is if the claim is disputed. So if you get gonged at the commission level, if you appeal, the appeal process has a mediation process. And so that's an aspect of being able to settle it in a contested fashion on appeal and not have to have a medical cost projection when you get remanded back to the commission. I guess another aspect of the appeal process is there's no stay. In fact, hey, good timing. Someone
I was
came in with a
just gonna
question.
say that, yeah.
Does the appeal stay the award? And it doesn't, except it does stay it for past medical benefits and attorney's fees. So if the award awards past medical benefits and attorney's fees, they are stayed. Everything else is not stayed. So ongoing compensation benefits, past compensation benefits, future medical benefits, all of that stuff is payable during the appeal process. But the case I was saying, we settle it, very bad case. We settled it on an appeal and we're going to get out of paying a lot of medical bills because we settled it in a contested posture and we're going back to the commission to get it approved. And claimant's attorney is going to go to his IME doctor and say, this person doesn't need any more medical care. And so that's a favorable aspect of the appeal process. The other thing is the appeal process is very costly for the claimant as well. The injured worker would be expected to pay $5,000 or whatever for his medical deposition too. So that's one aspect.
And
Oh,
go
uh,
ahead. No, go ahead.
sorry,
Go
I
ahead.
see this
I know,
question.
I know. I saw a question too about. Go ahead. You go first. Go ahead.
So medical providers, if they have a dispute on what you paid or if you haven't paid anything, they can file a medical claim dispute with the commission. The commission clerical someone or medical staff somewhere is going to calculate what the doctor is entitled to, and then the commission's going to order what they call an order nisi. Basically says you pay this amount, and if you dispute it, you have so many days to dispute it. If you don't think the treatment was reasonable, necessary, or causally related, you can contest or controvert the order nisi, and then you'll get a hearing before the commission. So
Yeah, and there's no formal UR process in Maryland like there is in Pennsylvania. At that point, I would tell you, you get that order nisi, you can get an IME with an opinion as to whether or not that treatment's A, related, or B, not reasonable and necessary, or both. And another question, I noticed we were talking about 5 years. They were talking, the question is a 5-year statute from what, last payment, medical bill, et cetera. It's 5 years from the date of that awarding that permanent partial disability.
it's the award of or the last payment of compensation. So you have the award, and if the award awards like 150 weeks of permanency benefits, then after that 150 weeks of permanency benefits, then you have 5 years to go for worsening condition.
Yeah, that's something we didn't bring up. The permanent partial, we're down to our last minute, but the permanent partial award, it's awarded in weeks. And that gets paid from the date the last temporary total disability payment was made. So if it's a short period, you could, let's say it's been 2 years from the date of last payment of temporary total, and that you're awarded 52 weeks, you're going to pay that on one lump sum. But if it's a larger, you could be paying that on a weekly basis going forward. So it's after you make that last payment. And I think, go ahead.
I was just going to say, we have an outline that we'll try to get on the website or send it directly to you all if you're interested in receiving it that way. The other thing we can get the compensation benefit chart out to folks.
Yeah, I also have a packet of commonly used forms that I printed. If that would be helpful, we can send all of that in. I apologize for any questions we didn't get to, but I think we have everybody's email. We will answer every question that has come in, I promise.
The one other aspect of temporary total disability indemnity benefits, when you're calculating the TTD rate, it's the whole number above a fractional number. So if you come out with a TTD rate of $351.50, it's going to be, in the commission rules, the labor and industry statute says it goes up to the next highest whole number. So it would be 352. And with that, thank you, everyone.
I
And
think you have our contact information, probably went out with the invitation. Please email us and we will split up these questions and make sure we answer all the questions.
And someone had a question about IME physicians. I think our next webinar may have an IME physician on there, so there'll be opportunities to ask that doctor about the IME process, as well as his belief. He's an upper extremity specialist, and we can get into that as well. And if you have other suggestions for webinars, please let us know. Or if you want more information on a specific area, please let us know that as well. So thank you all for participating today, and I guess we'll see you next time.
Yeah, thank you very much.
Thank you.